afternoon, everyone. Thank you for joining us for today's online talk, which will be starting shortly at 3 p.m. For those who are here early, thank you for waiting patiently. While you're waiting, we would like to share with you a short video from the firm.
I founded the firm in September 1985 with the vision of seeking truth and justice for our clients and not just winning their cases. Over the years, the team has achieved many significant milestones. We are today recognized by the Legal 500, Asia Law Profiles, and Asian Legal Business as a recommended firm in various practice areas. While we have embraced technology to make our services efficient and responsive, we continue to grow on the bedrock of meticulous preparation and hard work, for which there is really no substitute. As legal practice becomes increasingly international, we keep ourselves ahead of the curve with our relationships with lawyers from around the world. Our firm is a founding member of the League of Lawyers, a growing international network of law firms in 20 Asian and European countries.
We believe in partnering with our clients to protect and grow their business. We achieve this by holding firm to our values of integrity and justice, while giving our best to deliver effective and efficient solutions. Instead of just legal services, we focus on developing great working relationships based on understanding and respect.
The firm invests in its team and emphasizes professional development. We are keen to share our knowledge and publish our articles on our website. And we also give back with our corporate social responsibility activities. We cultivate a passion for the law and enjoy what we do. This brings out the best in us for our clients today and tomorrow.
We regularly advise foreign clients, including many Chinese investors, and have a ready appreciation for different ways of doing business. In corporate matters, we offer relevant and commercial solutions, often raising issues that clients may or may not have realized before. In negotiations, we believe in facilitating win-win outcomes.
Today's online talk with entitled Employee Misconduct and Domestic Inquiry. My name is Suan. I'm an associate with Wong and Associates, and I will be your moderator for today's session. Before we start today's session, allow me to introduce the firm and what we do. Wong and Associates is a mid-sized law firm that was founded in 1985 by Datuk Ma Wing Kwai. Our able team today comprises of 22 lawyers and a support team of 19. Datuk Ma is a consultant with the firm following his retirement from the Court of Appeal bench in 2015. The firm continues its tradition today of working primarily with small medium enterprises, family businesses, and individuals. We are a full-service law firm with a corporate department, a dispute resolution department including litigation, adjudication, and arbitration, a dedicated employment department, and a department focused on servicing the needs of individuals and families. Our practice groups indicate some of our focus areas, which are supported by talents from both our corporate and dispute resolution teams. Today's talk is part of our MWKA online talk series. By way of background, we have been organizing monthly lunch talks at our office since 2013, some of which were also broadcasted live. But with the COVID-19 Movement Control Order, or MCO, we have moved online in order to continue with our objective of sharing knowledge, raising awareness, and encouraging networking for clients, potential clients, and in-house counsel. This is the 21st talk in our MWKA online talk series. Visit our website at mawingkwai.com for more information, to read our articles, and to sign up for more upcoming talks. Before I continue, please be reminded that this talk does not constitute a legal advice. In the event you require specific legal advice to your matter, please contact us for our complimentary legal consultation. Details will be given at the end of this talk. Now, allow me to introduce both our speakers for today. Firstly, Ms. Diana Cheak, our Senior Associate in our Dispute Resolution and Employment Department. She holds a Bachelor of Laws from University of Malaya and was admitted to the High Court of Malaya in 2014. Diana is also a certified mediator. Next, we have Ms. Jasmine Wong, who will also be our first speaker for today. She's an associate in our dispute resolution, employment and individuals, and family departments. Jasmine holds a Bachelor of Laws from Aberystwyth University. She was admitted to the Malaysian Bar in 2017. Our speakers hope to complete today's talk by 3:45 p.m. and thereafter proceed with the Q&A session. So, if you have any questions, please don't forget to post them up on Slido and our speakers will address them later. You should have received a link to Slido during registration, but I will leave the slide up for a while so that you can scan the QR code before we move on. Alternatively, you can go to Slido's webpage and key in the code 21229. I repeat, 21229. As an employer, what can you do if your employee violates the company's rules or policies? Would it be sufficient to discipline the employees internally, or is the employer now entitled to summarily dismiss the employee? During this talk, both our speakers will explain the legal principles in handling employee misconduct. Jasmine, our first speaker, will start things off by explaining the law governing the employee misconduct, and she will also give examples of misconduct. Later, Diana, our second speaker, will explain what is a domestic inquiry. She will also elaborate on the guidelines of holding a domestic inquiry, and she will conclude the talk by explaining the consequences of failing to hold a domestic inquiry. With that said, I'll now invite Jasmine to share her insights. Over to you, Jasmine.
Thank you, Sue-Ann. Now let's talk about employee misconduct. All of us know that the relationship between an employer and employee is fiduciary in nature. What does the word fiduciary mean? It means that the relationship belongs to a trust or trusteeship. It also means that when an employer engages or hires an employee, he has confidence and belief that the employee would faithfully execute his duty and protect and further the interests of the company. So in this case, Azahari Sharum against Associated Pan Malaysia Cement Sdn Berhad, it says that if the employee did something or failed to do an act which is inconsistent with that fiduciary relationship, that act or omission will be mala fide, in bad faith, and therefore may lead to misconduct. So what exactly would constitute misconduct? The Federal Court in Akira Sales and Services states that there are actually too many acts and too numerous to be categorized. But suffice to say, misconduct in employment need not amount to a crime to justify dismissal. So any acts which would include insubordination, being absent from work, leaking confidential information, or even internet abuse would amount to misconduct and justify dismissal if it is appropriate and reasonable. And again, in these two authorities, it emphasized that an employee would need to do something that would have injured the employer's trade or business, and that would inconsistent with the faithful discharge of his duty. These acts would then therefore amount to misconduct and, as these authorities have already said, justify immediate dismissal. So what happens to the employee if the employee is found guilty of misconduct? In Section 4, Sub 1 of the Employment Act 1955, it allows the employer to actually dismiss the employee without notice, downgrade the employee, or impose any lesser punishment which the employer would deem fit and just. And if the punishment of suspension is necessary, it shall not exceed the period of 2 weeks. But bearing in mind that this Employment Act 1955 governs employees who actually earn below the wages of 2,000 ringgit. If above that, we would have to look into the terms of the employment contract. And the usual situation is that the employment contract would have provided for the conduct that the employer can take in the event of misconduct by the employee. I would like to explore several examples of misconduct. What happened here in the case of Dahlia Ashari against Malaysia Airports Niaga Sdn Berhad is that the employer actually went on a holiday to Thailand while being on medical leave. The court held that this was a serious misconduct. So what happened here was that the employee had actually submitted her leave application to the company, but it was pending approval by the company's management. So what happened on the first day of work, on her supposed first day of leave, was that she went to work. And on her way to work, she allegedly suffered numbness in her upper limb. She then went to a doctor and she obtained the medical leave. The medical certificate was then given to the company and she was allowed to go on a medical leave. So the company found out that she eventually went on a holiday to Thailand as scheduled. And the company also found out that she posted videos of her holiday, photographs on her personal Instagram account. So when this matter went to the industrial court found that the employee was malingering. What it means is that the employee pretended to be sick and feigned sickness in order to avoid duty. The employee also showed sheer defiance and rebelliousness when she posted videos and photos on her Instagram account. And because of this, the industrial court found that the dismissal was with just cause and excuse, as she had abused the medical leave. So if you're on medical leave, stay at home. The next case talks about an employee who was dismissed after being tested positive for drugs, morphine. When the employee was hired by the company, he had actually signed an acknowledgement of the company's drug and alcohol policy, which required him to undergo random drug and alcohol tests. The company requires all those on board of the premises, which was actually the ship, the vessel, to be fit at all times so that the employees can perform their normal and emergency duties without being affected by the effects of drugs and alcohol. So when the employee was dismissed, after failing this drug test, the industrial court found that the dismissal was fair because failing such a drug test is a major misconduct which was clearly inconsistent with the relationship, with the fiduciary relationship between the company and the employee. And this was even so, even if there was no allegations that his work performance was affected or that the employee had acted inappropriately while under the influence of drugs. Some dismissals are fairly straightforward as they are gross misconduct. But what about some things that you have done outside office hours? So in this case of Sebastian Matthias Bohim, the employee was found drunk, misbehaving at the hotel bar, sexually harassing and assaulting the hotel staff and guests. And in this case, the employee was dismissed for his conduct, which was done outside working hours. The employee, of course, argued that this incident happened after the office hours and it was personal and done on his own time. But bearing in mind the facts of the case is that the hotel is actually a corporate partner of the company, and they have a corporate agreement wherein the company would send their employees to the hotel for outstation work purposes. And the dismissal was accordingly done with just cause and excuse because the employee's actions had shown himself to be a staff of the company who could not be trusted to uphold the company's values. And the employee's conduct of sexually harassing and assaulting the guests and staff had potentially exposed the company to legal risk and harmed the company's reputation. Therefore, the industrial court found that the company had rightfully dismissed the employee. In this case, the employee was drunk at the company event, at specifically the company's annual dinner, and he was also misbehaving. The industrial court found that the dismissal was unfair because it came to light that another senior manager who was also drunk and misbehaving at the same event was merely let off with just a warning. The outcome of this case would have been different if the fact of this senior manager who was just let off with a warning did not come to light. So the industrial court actually found that the dismissal was unfair because they did not want to condone the discrimination between this employee and the senior manager. So even though the employee had misbehaved, the dismissal was held as unfair. But because of the fact of his misbehavior at the company's event, the court deducted 50% of the total amount of compensation for unfair dismissal, which was awarded to the employee. But bearing in mind, like I said, the outcome would have been different if the senior managers was reprimanded with the same level of punishment as this employee. In the next case, which talks about insubordination, this employee was dismissed because she refused to follow her superior's instructions to make payment for corporate expense and make adjustments to the company budget. She then wrote an email to say that she no longer report to the superior. The industrial court found that the employee was guilty of insubordination, but the punishment of termination from her employment was too harsh of a penalty. This matter went on appeal, and the Court of Appeal affirmed the industrial court's decision, bearing in mind also that the employee had, this was the employee's single act of insubordination and the first misconduct in the employee's 20 years of service. In all the other cases which discuss about insubordination, there are a few elements which we need to establish. First, the employee's instructions must be lawful and reasonable. The employee's disobedience subsequently must be willful and not just merely an oversight or negligence. And if these two are established, the company should then take a punishment which would be appropriate. So in this case, for a single act of insubordination and the first misconduct in her long years of service, the immediate dismissal from employment was too harsh. Perhaps a warning would be sufficient to reprimand this employee. The last case, which concerns absenteeism. Section 15, sub 2 of the Employment Act states that the contract of service would be deemed breach if the employee is continuously absent from work for more than 2 consecutive working days without prior leave of the employer. The Federal Court in Pan Global Textiles Berhad Pulau Pinang held that absenteeism is a serious misconduct and a gross violation of discipline which justifies immediate dismissal. But of course, we would have to look at the nature of the employee's work. If the nature of the work allows the employee to work from home, or perhaps a salesperson is required to travel often to meet clients outside to generate sales, it would not be reasonable for the company to require and reprimand the employee if he is not present at the office premises. And if the company is aware that an employee has been absent from work for a couple of days without any reasons or notification to the company's management, the company will need to take immediate action. If the company let it slide, the court would deem that the company to condone this alleged misconduct under the principle of condonation, and the company will not be allowed to rely on this condoned offense as a ground for dismissal later. And this principle was stated in the case of Zulkifli Ibrahim against Airport Limo. So what happens if there were allegations of misconduct brought against you? My colleague Diana will now address the steps to be taken and whether or not a domestic inquiry is necessary. Over to you, Diana.
Thank you, Jasmine. Good afternoon, everyone. My name is Diana. I will continue the presentation by explaining what is domestic inquiry. What are the best practices and guidelines to follow when a company holds a domestic inquiry? And the third one, what are the consequences if a company fails to carry out a domestic inquiry or decides not to carry out a domestic inquiry? What is domestic inquiry? So a domestic inquiry is a process to find out the truth, facts or circumstances regarding the misconduct alleged by the employer against the employee. Domestic inquiry is an inquiry created by the company against the employee who allegedly committed certain acts of misconduct. The process begins after the issuance of the show cause letter to the accused employee. And once the employee responds to the show cause letter and the response to the show cause letter is unsatisfactory, then the employer can consider commencing a domestic inquiry against the employee. It is pertinent to bear in mind that domestic inquiry is merely a fact-finding exercise. The panel of the domestic inquiry does not decide on the disciplinary action or punishment to be taken against the employee. The company will decide that. When we talk about domestic inquiry, these are the two sections that are relevant when we talk about domestic inquiry. The first section would be section 14 of the Employment Act 1955. So as Jasmine mentioned just now, this Section 14 would cover employee who earns 2,000 and below. And this section says that employer may, on the grounds of misconduct, terminate an employee without notice, downgrade the employee, or impose any other lesser punishment as he deems just and fit after a due inquiry is carried out. And then Section 20 of the Industrial Relations Act says that an employee who considers that he has been dismissed without just cause and excuse may file a representation to the industrial court. So there's due inquiry equals to a domestic inquiry. The short answer will be no. In the case of Ladang Sungai Tamu and National Union of Plantation Workers, the court held that the term due inquiry has not been defined, but the industrial court have quite clearly established the rule that the employer's procedure for dismissal on the ground of misconduct must follow the rule of natural justice. In short, it means that the employee must be informed of the grounds alleged against him, and the employee must be given a chance to answer the charge. So right to be heard must be accorded to an employee if an employee has committed an offense or a misconduct. Next, what are the guidelines and best practices for domestic inquiry? First of all, we usually start off, when an employee is found to have committed misconduct, we always start off with a show cause letter. So in the show cause letter, the employer must state clear and precise allegations. Who committed the misconduct, when it was committed, where it was committed, what happened, and how did it happen. So all this must be in the show cause letter. The company must make reference to the employment contract or the company handbook or the company policy where the alleged where the employee is said to have breached that certain clauses in the employment contract or the company handbook or the company policy. The show cause letter must state the deadline to respond to the show cause letter. So here, reasonable timeline must be given. If there are 10 charges against the employee, you can't expect the employee to give a response within 24 hours. That is not reasonable. You may also suspend the employee if necessary. And if suspension is necessary, it shall not exceed 2 weeks. The employer will still have to pay the employee's wages, half wages. And if the employee is found not guilty upon a due inquiry, the employer must pay back the remaining wages to the employee. This is stated under Section 14(2) of the Employment Act. Next, after the issuance of the show cause letter, the employee will have to reply to the show cause letter. So if the employee's explanation is satisfactory, so there will be no punishment against the employee. And if the employee was suspended during the period to show cause, the employer must pay back the wages during suspension to the employee. However, if the employee's explanation is not satisfactory, the employer may consider what disciplinary action to be taken against the employee. Or if in the case of a serious misconduct, it is always advisable that the employer issue a notice to attend domestic inquiry and later follow up with a domestic inquiry. And the employer may also suspend the employee if it is necessary at this stage. Next, if a domestic inquiry is required, then the employer will have to issue a notice to attend domestic inquiry to the employee. So in this notice, again, the employer must state precise and detailed charges: who, when, where, what, how. It is the same as the show cause letter. The employer must state the date, time, and venue of the domestic inquiry. If the employer doesn't want the employee to be legally represented during the domestic inquiry, the employer must state that the employee, that this is an internal matter, the employee should not be legally represented during the DI. So this must be stated in the notice to attend domestic inquiry. In the notice, the employer must also state that the employee is allowed to produce documentary evidence and witnesses during the domestic inquiry. And the employer may also suspend the employee at this stage. But bear in mind that suspension you can only suspend an employee for a maximum of 2 weeks. Next, I'll briefly explain the procedure of a DI. So before the company carry out a DI, the company will have to appoint a DI panel. So usually it is in odd numbers. It's either 1 to 3 panel members will be appointed. Panel members must be more senior than the accused employee. The prosecuting officer and the investigator or the investigating officer should not be sitting on the DI panel. And it is good practice if you can get a senior employee from a different department to sit on the DI panel. Then you will have your domestic inquiry hearing. So during the hearing, the prosecuting officer will start the company's case first. So at this point in time, the prosecuting officer will adduce documents and witnesses and question the accused employee. So we call this stage as the examination in chief. Then the accused employee will cross-examine the company's witnesses. And the company may re-examine its own witnesses if necessary. After that, the accused employee will then adduce his documents and witnesses. So the same process will apply. The prosecuting officer then cross-examine the accused employee's witnesses, and then the accused employee can re-examine if necessary. So after the DI process, the panel members will have to sit down, discuss, and examine on the available evidence. And then the DI panel will decide whether the employee is guilty or not guilty and recommend disciplinary action that can be taken against the employee. Bear in mind that panel members do not decide on disciplinary action. They can recommend, but they can't decide on which disciplinary action to be taken against the employee. The company will decide. Okay, I have also listed a list of guidelines and best practices when you hold the domestic inquiry. Charges must be drafted precisely with details of misconduct. This is very important because there are cases where defective charges, because of defective charges, the whole domestic inquiry was declared null and void. Second one, panel members should not be investigating officers or prosecuting officers. Investigating officers must not be related to the incident or the individuals involved. The employee must be given right to be heard. The employee should be given full opportunity to present his case, including adducing evidence and witnesses to support his arguments. Next, the proceeding of the DI must be recorded, and the transcript of the proceeding must be verified and signed by the accused employee at the end of the domestic inquiry. During the domestic inquiry, panel members may ask clarifying questions during the proceeding, but panel members should not take on the role as the prosecuting officer interrogating the accused employee or threatening the accused employee. This should not be done. Last but not least, panel members should consider and analyze all available facts and evidence before finding whether the employee is guilty or not. Next, I've listed down a few sample cases where common mistakes where you can see common mistakes were done by employers when holding domestic inquiry. So the first case talks about defective charges. In the case of Esso Production Malaysia and Maimuna Ahmad. So in this case, this is a judicial review case where the matter was referred to the industrial court and an award was granted in favor of the claimant. So after that, after the award was granted in favor of the claimant, the company applied to the High Court for an order of certiorari to quash the award that was given by the industrial court. At the High Court stage, the High Court judge held that the two charges proffered against the claimant did not contain the particulars of date, time, and place of the offences where the offences were alleged to have been committed, even though those are material particulars which must be stated in charges. And the High Court also held that a defective charge for one of material particulars is void ab initio. And on such improper charges, the finding of guilt of the claimant by the company's board of inquiry should be set aside. And the court also held that the dismissal of the claimant was not done with just cause and excuse. The Court of Appeal, when the matter went to the Court of Appeal, the Court of Appeal upheld the decision of the High Court. The Court of Appeal said that, agreed with the High Court and said that when you draft charges, the date, the time, and the place of offences are important details that should be included in the charges so that employees will know what to respond to, or how or he or she would be able to prepare a proper defense to the charges. Next, we'll talk about duplicity of roles. In the case of Metal Box Malaysia Berhad and Metal Industries Employees Union. In this case, the industrial court held that the domestic inquiry carried out by the company was not properly conducted for, among other reasons, that one of the two panel members was the investigating officer. So this is a clear breach of natural justice. Also on duplicity of roles, in the case of Abdul Ghani Abdullah and IFCO Malaysia Sdn Berhad. In this case, the investigating officer and the prosecuting officer at the domestic inquiry, they are the same person. And then the same person found the appellant was guilty of misconduct and recommended for his dismissal. And the same person also signed the appellant's termination letter. So the High Court held that the domestic inquiry was tainted due to the role and conduct of the company witness, one, which were in breach of principles of natural justice. The High Court judge was of the view that the investigating officer and the prosecutor had indeed played multiple roles such that the conflict of interest on his part was blatant and obvious. So you need to have different person to play different roles during the domestic inquiry. You cannot have one person to play the role of the investigating officer, the prosecuting officer, and at the same time sitting in the DI panel. Next, we'll discuss about this case, where this case, the company failed to adhere to the company's handbook, where the company's handbook actually provide for a procedure for domestic inquiry if an employee is found to have committed misconduct. So in this case, the company issued a show cause letter to the claimant. And then despite responding to the show cause letter, the employee or the claimant was terminated from employment. The court looked at the company's handbook and found out that in the company's handbook, the company handbook provides that no disciplinary action should be taken against an employee without investigation. And the company must And in serious cases, the company must hold an official inquiry. It is also one of the salient terms in the company's handbook where warnings should be given to the employee, and it must be recorded and placed in the personal file if the employee is found to have committed misconduct. And where a verbal or a warning or written warning is given, that warning should state the nature of the offense or lapse and the time allowed for improvement to be achieved. So during trial, the company's witness actually testified and admitted, among others, that there was verbal warning, but there was no record of any verbal warning. There was no warning letter given to the employee, and the company did not carry out a domestic inquiry or an investigation as provided in the company's handbook. So in this case, the industrial court held that the company's failure to carry out an investigation or a domestic inquiry expressly contravened the provision in the company handbook. And because the claimant had not been given an opportunity to defend himself, the industrial court held that the dismissal was not done with just cause and excuse. Next, can an employer substitute its own opinion in place of the facts that were found by the domestic inquiry? This is also one of the common questions that employer usually asks. So a short answer would be the employer should accept findings of the domestic inquiry. So in the case of Pelabuhan Tanjung Pelepasrian Berhad and Industrial Court Malaysia, this is a fairly recent case decided this year. This is a judicial review case where the company filed an application for judicial review at the High Court to quash the award handed down by the industrial court in favor of the employee. So in this case, the company held a domestic inquiry where the employee was given the opportunity to produce evidence and witnesses to defend himself from all the allegations that were made against the employee. And at the end of the domestic inquiry, the panel found that the employee was not guilty of the charges. However, notwithstanding the findings of the domestic inquiry, the company's management found that that they have lost the necessary trust and confidence in the employee and terminated his employment. So the court in this case laid down 3 points. The court said, firstly, that if the management refused to accept the findings of the domestic inquiry set up by the company itself, it is a clear violation of Section 14 for finding the guilt of misconduct or otherwise is vested in the domestic inquiry. The second point, the court said that if the domestic inquiry found the employee not guilty and therefore there is no misconduct, the employee cannot be terminated by way of Section 14 of the Employment Act. And the court said that the company cannot substitute its own opinion in place of the facts that were found by the domestic inquiry. In the third point, the court said that, however, on the other hand, should the domestic inquiry, after making a finding that the employee was indeed guilty of misconduct, but do not or has no jurisdiction to decide on the punishment to be taken against the employee, then the company will have the prerogative to decide on what kind of punishment to be taken against the employee. Next, we'll look at what are the consequences of not holding a domestic inquiry. It is tried law that the absence of the domestic inquiry is not fatal, as this procedural impropriety can be cured at the hearing before the industrial court. So this is a principle laid down by the federal court in the case of Wong and Sharika Hong Leong Assurance Berhad. However, based on the cases that we have seen, failure to properly conduct an inquiry could result in an unfavorable finding from the industrial court in the event the accused employee files an unfair dismissal claim. In this case, Papua Arokia Sami and Malaysia Parquet Floors Industry Sdn Bhd, the court held that the employer, in denying the claimants his statutory right to due inquiry, had shown the dismissal procedure to be unfair. The failure to hold a domestic inquiry had made the employer's decision to dismiss arbitrary. The court also held that there was no investigation by the company into the allegation against the claimant, and the claimant had been dismissed the very next day after the incident. The speed at which the decision to dismiss him had been taken seemed to indicate that it had been a vent for feelings of wrath. The court also found that the company had not given any reasons as to why they had chosen the severest form of punishment and what factors had been taken into consideration. The court found out that there was no evidence that the claimant had been a problematic worker, and the episode where the claimant hit the chairman appeared to be an isolated incident. Sorry, I skipped the facts of the case just now. Okay, so in this case, right, the claimant worked for the company as a machine operator for 21 years. And the claimant was scolded by the company's chairman for not operating the machine. And this happened on a fine day. And in response to this, the claimant threw a piece of wood at the chairman. But thankfully, it did not hit the chairman. And this had resulted in his dismissal. So the court actually found that throwing a piece of wood at the company's chairman was a misconduct, as it had been an insolent act towards a superior. However, the court was also of the view that the claimant had been dismissed on grounds of misconduct without any inquiry. So like what I have shared just now, the court found that there was no domestic inquiry held by the employer, and the employee was dismissed the very next day after the incident. And because this is a one-off incident, the court was of the view that the punishment of dismissal is a severe punishment, and the dismissal of the employee was without just cause and excuse. Okay, let's look at questions.
Thank you, Jasmine and Diana, for sharing with us. We'll now take questions that some of you have posted on Slido. You can ask us questions by posting on Slido. The code is 21229. Because we have quite a fair bit of questions today, we will focus on those which concerns misconduct and domestic inquiry. For our first question, how long should the employer wait to issue the next warning letter for the same issue if it's not resolved yet? Jasmine, perhaps you can take this. Sorry, Jasmine, are you there?
Sorry, I was muted just now. The first question, is it?
Yes. How long should the employer wait to issue the next warning letter for the same issue?
We usually advise employers to give sufficient time of maybe 7 or 14 days to the employee to address the issues in the warning letter. We don't want to be seen as pressuring the employee to come up with a response. And most of the time, there are also situations where the employee would request for additional time to respond. And it would be in the company's good faith, is an act of good faith to give additional time. So usually 7 or 14 days.
I see. Similarly, for the next question, is a warning letter mandatory?
To add on what Jasmine has mentioned just now, there is no law to say how long should an employer issue the next warning letter after the issuance of the first warning letter. So let's say if after issuing the first warning letter, the employee still commit the same misconduct, the employer may issue a second warning letter or take other disciplinary action. So for an example, if the employee did not come to work for 2 days, let's say, and a warning letter was issued to him, and after issuance of the warning letter, maybe 2 months down the road, he does the same thing again. Then the employer may consider issuing second warning letter, or the employer may also, for an example, deduct the employee's salary. This could be another disciplinary action that can be taken against the employee. So there is no law to say how long we should wait to issue a second warning letter or to take other disciplinary action against an employee.
I see. Thanks, Diana. Perhaps you can continue on by this answering the second question. They ask, is a warning letter mandatory? What about show cause letter?
Okay, a warning letter is not mandatory. It is a form of disciplinary action, but it is not mandatory. And what about a show cause letter? It is good practice to always start off with a show cause letter before deciding what kind of disciplinary action to be taken against the employee. This also, it follows the rules of natural justice, where the right to be heard should be given to the employee before the employee decides whether the employee is guilty or not, and what disciplinary action that can be taken against the employee.
Right. Thanks, Diana. We'll move on to the next question. Jasmine, if there is a misconduct, must we lodge a police report?
The lodgement of a police report is not necessary, but depending on the misconduct which is alleged to have been done, if it concerns misappropriation of assets, cash, for example, or it involves allegations of sexual harassment, where someone has actually suffered personally any injuries, then it would be best for the company to lodge a police report, as all of this would be evidence in any proceedings in the future.
Thanks, Jasmine. Next, employee in his probationary period committed a misconduct. Is it necessary to issue a warning letter, or we can use this to not confirm his employment? Diana, perhaps you can take this?
Yeah, sure. Okay, so if an employee in his probationary period and committed a misconduct, well, I think you should look at if the probationer is an employee under who is covered under the Employment Act, you should still complete a due inquiry before issuing a warning letter. Well, you do not have to, if it is for a simple misconduct, perhaps you do not have to go through the full-blown domestic inquiry, but you still have to issue a show cause letter, get the probationer to show cause or to respond to the show cause letter. If it is the employee is an employee who is not covered under the Employment Act, then you should look at the contract of employment. What does the contract say? But it is always a good practice to always ask the employee first, why did you do this? So this will be done by way of a show cause letter. Because a probationer is accorded the same rights as a permanent employee. Yeah, if they feel that their dismissal was done without just cause and excuse, they can also file an unfair dismissal claim against the employer in the industrial court.
I see. Thanks, Diana. For our next question, let's take this. What if the company is so small, i.e. very few staff, seniors, or is a startup company, it cannot support a domestic inquiry? Diana?
Okay, so as I mentioned just now, if it is a minor misconduct, then perhaps you do not have to go through a full-blown domestic inquiry. You can always start off with issuance of a show cause letter, get the employee to respond to the show cause letter, and if evidence is sufficient to prove that the employee is guilty, then you can proceed with disciplinary action against the employee. For an example, like the case that Jasmine mentioned just now, if the employee is on medical leave, and then he or she posts pictures or videos of him or her going for a holiday, then there's a clear misconduct, and you do not have to go through the full domestic inquiry before deciding what kind of disciplinary action to be taken against the employee. But if it is a serious misconduct, for an example, a breach of fiduciary duty or theft, yeah. If you are a small company with very few staff, what you can do is to outsource your domestic inquiry. Get people from the same industry to sit on the panel of domestic inquiry, and actually this is a good practice because the principle of natural justice will be upheld in this sense. There will be no allegations of biasness because people who sit on the DI panel or conduct the domestic inquiry, they are not related to the company. So they are impartial, in other words. So yes, outsourcing a domestic inquiry is possible.
Right. Thanks, Diana. Next, can we terminate an employee due to low performance? Jasmine, let us have your thoughts.
The general answer is no, because if you want to terminate an employee based solely on poor performance, there are actually several criteria that the company will need to satisfy. The employee would first need to be warned about the employee's poor performance, and this can be shown from the warning letters. And then the employee would need to be given sufficient time and opportunity to improve. So the company can give trainings or send the employee to courses pertaining to the course to the job duties. And after all of these have been done and time have lapsed, and still the employee failed to improve his performance or do a better job at it, only then the company can consider terminating the employee based on poor performance. But usually the court in this kind of cases would look at documentary evidence to see whether the employee have already been given sufficient opportunity to improve himself.
Thanks, Jasmine. Our next question, is it possible to issue a second warning letter on a different misconduct? Diana, perhaps?
Yes, it is. You can issue a warning letter for different misconduct. Okay.
Next, What should we do after issuing a warning letter? Diana, perhaps you can just briefly answer this.
After issuing a warning letter, you should observe and see whether there's any improvement on the employee's side. So if there's improvement, then that's good. If there's no improvement and the employee repeats the same misconduct, then the company may issue another warning letter or consider taking other disciplinary action against the employee.
Okay, thanks, Diana. Our next question is, what if the employment contract does not state what amounts to misconduct? Jasmine?
The company will actually need to look into the nature of the alleged misconduct and determine if that particular conduct was done in bad faith and it would have affected the company's interest or harm its reputation. But again, it's important to remember to give the employee an opportunity to explain why that particular conduct has happened, and only based on the employee's reasons, then the company would be equipped to determine if it is a misconduct, because there are many conducts which can amount to misconduct, and usually employment contracts don't specify what will actually amount to a particular misconduct.
Thanks, Jasmine. Next, is it better to appoint lawyers or outsiders to be panel? I believe this is similar to just now what Diana answered. Diana, do you want to briefly answer this again?
Well, the panel of the DI does not necessarily have to be lawyers. As I said just now, people from the same industry can sit on the panel. If you want to appoint lawyers to sit on the panel, the DI panel, it can also be done. So there is no hard and fast rule on that. It depends on your level of comfort.
Right. So basically, it depends on the employer, lah.
Yes, correct.
Okay. Our next question. What should an employee do if the employer has been pressuring the employee to resign? Jasmine, perhaps you can take this.
Depending on the situation, if the employee had actually resigned because the employee was pressured to do so, that would be a claim in the industrial court for unfair dismissal, because such a situation of forced resignation is a form of dismissal, or again, depending on the facts of the situation, that may also amount to a case of constructive dismissal. That means that whatever the conduct of the employer had caused the employee to feel that it is not possible for the employee to continue working with the company anymore, and therefore the employee resigned from the company. So either these two grounds, the forced resignation ground or the constructive dismissal ground, would allow the employee to bring a claim for unfair dismissal in the industrial court.
Thanks, Jasmine. Next question. What should an employer do if an employee has been missing without informing any superiors for more than 3 days? Jasmine?
Depending on the terms of the employment contract again, the employer should issue a show cause letter or contact the employee to find out why the employee had failed to, was missing from work for more than 3 consecutive days.
Thanks, Jasmine. Next question. Can we terminate the employee on the 3rd warning letter due to the same attitude? Diana, what do you think?
It depends on what kind of misconduct. So let's say, for an example, if an employee is absent for work for more than 2-3 days without informing the superior or the employer, and you have given 3 warning letters. So, and if the employee does it again for the 4th time, yes, you may terminate the employee because there's a case to say that absenteeism is a severe misconduct. So it always depends on what kind of misconduct you're talking about.
Thanks, Diana. Okay, our next question. What is the proper procedure to issue a warning letter? Diana?
As I think I've already mentioned just now, always start off with a show cause letter. Then if the company feels that the employee is guilty, then you can issue a warning letter.
Thanks, Diana. Next question. Can we hold a salary if an employee absenteeism for more than 1 week with failed connection to the company? Jasmine, perhaps you can take this.
Sorry, I don't really understand the question actually.
I think the question is whether you can suspend the salary of the employee if the employee fails to report to work for more than a week.
Well, generally, no, you cannot withhold the employee's salary, but actions should be taken by the company to address the absenteeism as soon as possible.
Yeah.
Okay. Next question. Can we have a copy of the slides? Yes, you can. This slides for this talk and for all our previous talk as well, they're available on our website. So you can just go to our website, maoinquire.com, and get a copy. Next question. If an employee thinks that he will not be given a fair investigation, can he engage a lawyer to represent him instead? Diana?
To represent the employee during the DI, it depends on whether the employer allows the employee to bring in his lawyer during the DI. But for the lawyer to attend the DI on behalf of the employee, I don't think so. The employee himself will have to attend the DI and answer all the charges leveled against him during the DI. But the employee can always seek legal advice from his lawyer before he attends the domestic inquiry.
Thanks, Diana. Due to time constraints, we will be taking the next 3 questions before we end our talk. For our next question, what should the employer do if there is a breach of confidentiality contract done by employees? Diana, what do you think?
If there is a breach of confidentiality, of course, first what the employer needs to do is investigate first what kind of breach, what kind of harm or damage that it has caused to the company, and then issue a show cause letter to the employee. Then only decide on the next course of action.
Can I just add on to that as well? In the event the company decide to bring a claim against the employee for breach of confidentiality, it is important to remember that the company will need to specify what exactly that has, what sort of confidential information has been breached or leaked by the employee. Because if the company failed to prove this element, there are cases to support that the company's claim against the employee would fail, because the employee will need to know what exactly he or she has breached.
Yeah, so the charges level against the employee must be very clear and precise. What kind of who did what, when, how did the employee breach the confidentiality clause? All this must be specified in the show cause letter. And later, if there's a domestic inquiry, then in the notice of domestic inquiry.
Thanks, Diana and Jasmine. Our next question. If staff refuse to follow the shift schedule, can we issue a warning letter? Jasmine, perhaps you can take this.
Yes, you can issue a warning letter because this will amount to insubordination. But of course, issuing a warning letter, and then whether it is appropriate subsequently to terminate the employee because of this issue, the company would need to look at the situation and see whether it is actually appropriate. But definitely a warning letter, it is advisable to issue one.
All right, and for our last question of the day, perhaps Jasmine, you can take this. If company needs extra days to investigate the misconduct, can they suspend the employee longer, and how much longer?
Okay, just now I mentioned that a suspension cannot exceed 14 days. That was actually provided in Section 14 sub 2 of the Employment Act, which governs employee who actually earn salary of not more than 2,000 ringgit. So if you actually earn more than that, you are not governed under the Employment Act. And if the company require more days to investigate the misconduct, I would say that they have the discretion to suspend the employee for the duration that they deem it fit. But bearing in mind also in Section 14 of the Employment Act, it did provide that if after the investigation it was found that the employee is not guilty of the misconduct, and during the suspension, if the employee was actually suspended without receiving any wages, the employee would need to, the company would actually need to reimburse the employee on that wages during the time period.
All right, thanks Jasmine and Diana for sharing with us. And that's the end for our Q&A session for today. Before we conclude, I have a few announcements to make. First, please join us again for our upcoming talks. On 15th of July, our partner Puan Sarah Kambali and our associate Mr. Marcus Leong will give a talk on Penjana, Short-Term Economic Recovery Plan, on tax exemption, RPGT, and stamp duty. Later, on the 29th of July, our associate Ms. Janessa Kok and our pupil in chambers, Mr. Ryan Cheong, will give a talk on drink driving offences in Malaysia. Secondly, please fill in our feedback form and tell us what you thought of our talk. The link to the form will be posted in the chat. We appreciate your comments so that we can continue to improve our MWKA online talk series for you in the future. Thirdly, please do follow or like our social media accounts. Fourthly, if you would like to speak with our lawyers, we offer a complimentary 30 minutes consultation over the telephone or over video conference. Please fill out the form in our website. The link is also posted in the chat. To our guests, thank you for joining us today.